Before we dive into today's story, stop for a moment and ask yourself this. What would you do if the most powerful judge in Washington threatened to send you to jail right there on the spot? Would you panic, stay silent, or stand your ground even as marshals stood ready to put you in handcuffs? If you want to see what true legal brilliance looks like under fire, stay with us until the end of this story. And if you're new here, make sure to subscribe. Hit the like button and drop a comment below about how you would react if you were the one standing in front of that bench. Because what you're about to witness is not just a courtroom confrontation, it's a masterclass in how knowledge can defeat intimidation. It began like any other Friday morning in Washington, D.C., inside the grand courtroom of Judge Beryl Howell, a figure both feared and admired across the federal bench. Lawyers filed in, reporters filled the gallery, and sunlight streamed through tall windows, casting long shadows across the marble floor. Yet beneath the calm, a storm was already brewing. At precisely 9 a.m., Judge Howell entered, black robe flowing, silver gray hair perfectly styled, her reputation preceding her like a warning bell. Known for her razor-sharp wit and an almost ruthless control over her courtroom, Howell had made seasoned attorneys tremble with nothing more than a raised eyebrow. But on this day, she had her sights fixed not on the prosecutors nor the defense counsel, but on a single observer seated quietly in the second row. That observer was Congresswoman Jasmine Crockett, a freshman representative from Texas. Most in the room saw her only as a politician, a lawmaker who had come to watch a high-profile case about free speech. What none of them realized, not even Judge Howell, was that Crockett was carrying a secret weapon far more powerful than political clout. She was, in fact, a seasoned civil rights attorney, armed with deep knowledge of constitutional law and a history of challenging judicial overreach. The judge's voice rang out, stern and commanding. "Congresswoman Crockett, I am holding you in contempt of court. You have 3 minutes to explain why I shouldn't order the marshals to take you into custody right now." The room froze. Reporters dropped their pens. Observers exchanged wide-eyed looks. Marshals shifted slightly, prepared to act. In a heartbeat, one of the most feared federal judges in America had just threatened to jail a sitting member of Congress. For most, this would have been the end, a humiliating moment of submission before overwhelming authority. But not for Jasmine Crockett, because in that instant, as silence blanketed the wood-paneled chamber, she did something no one expected. She straightened her posture, opened a leather portfolio she had quietly brought with her, and prepared to turn the tables on a federal judge who believed she held all the power. This was not just another courthouse drama. This was the story of unchecked judicial authority colliding with unshakable constitutional knowledge, and the extraordinary reversal that would follow. And it all began with 180 seconds to avoid jail. To understand the magnitude of what happened that morning, you first need to understand the woman who nearly sent a sitting congresswoman to jail, Judge Beryl Howell. For more than a decade, Howell had been one of the most powerful figures on the federal bench in Washington, D.C. Appointed in 2010 to the United States District Court for the District of Columbia, she quickly carved out a reputation as sharp, unyielding, and utterly fearless. From political corruption trials to cases involving national security, Howell was the judge attorneys whispered about in hushed tones before stepping into her courtroom. She had served as chief judge from 2016 to 2023, a period when her courtroom became the stage for some of the most politically charged cases in the nation. Legal analysts described her as thorough, exacting, and at times intimidating. Attorneys who faced her learned one truth quickly: you did not come unprepared before Judge Howell. At 67, Judge Howell carried herself with the authority of a lifetime spent in law. Her silver gray hair was always immaculately styled, her robe flawlessly pressed, and her demeanor precise. Every detail about her appearance projected control, discipline, and gravitas. When she spoke, her words cut through the air with the weight of experience. And when she questioned an attorney, she did so with razor-sharp precision that left even seasoned litigators scrambling for footing.
Those who had appeared before her often said she didn't just listen to arguments, she dissected them, word by word, until nothing but the raw truth remained. And if she sensed incompetence or disrespect, her response was swift, often laced with sarcasm or delivered with a withering stare. Over the years, Howell had presided over a gallery of high-profile defendants, lobbyists caught in corruption scandals, contractors accused of defrauding the government, even figures tied to national security investigations. Time and again, she demonstrated her intolerance for anything she considered political interference in judicial proceedings. More than once, she had sanctioned attorneys who attempted to play to the press. She had reprimanded those who tried to use the court as a stage. And, unlike many of her colleagues, she was not shy about wielding one of the most powerful weapons available to a federal judge, the contempt power. For Howell, contempt wasn't a last resort. It was a tool of order, a warning shot that reminded everyone who truly controlled the room. That is what made her confrontation with Congresswoman Jasmine Crockett so explosive. Because in Howell's courtroom, few dared to challenge her authority. Even fewer succeeded. And on that Friday morning, as she stared down the young Congresswoman in the tailored navy suit, Howell believed she was about to add another name to the long list of those who had fallen under the weight of her judicial hammer. What she didn't know, what no one in that room yet understood, was that this time, the gavel was about to be turned back on the judge herself.
To the casual observer sitting in that courtroom gallery, Jasmine Crockett might have looked like just another politician, a freshman congresswoman from Texas, sharply dressed in a tailored navy suit, pearls at her collar, notebook in hand. She appeared composed, attentive, and quietly curious. Few in that room realized that beneath the calm exterior was a seasoned attorney whose career had been defined by fighting power at its strongest points of abuse. Before her election to Congress in 2023, Crockett had built her reputation not in the halls of Washington, but in the trenches of civil rights law. A graduate of the University of Houston Law Center, she emerged as a fierce defender of those who had been silenced, intimidated, or pushed aside by systems of authority. Her caseload was not filled with easy wins. It was packed with challenges most lawyers would hesitate to touch. Cases of police misconduct, unlawful detentions, and violations of constitutional rights. She had argued and won before the Texas Supreme Court, an accomplishment that established her as a lawyer with not just passion, but precision. Even more importantly, she had become an expert in the very area of law that Judge Howell was now trying to wield against her, judicial contempt. Years earlier, Crockett had authored a widely respected law review article titled Constitutional Guardrails, the proper and improper use of judicial contempt powers. In it, she warned of the dangers of unchecked authority, noting that contempt powers, while necessary, could easily be abused if not tightly constrained by constitutional principles. The article had circulated in legal circles, cited in academic discussions, and even referenced in judicial training seminars. But few outside the legal world knew just how deep her expertise ran. By the time she ran for office, Crockett was already a name whispered in Texas courtrooms, a lawyer unafraid of challenging judges who overstepped their bounds. She had secured landmark victories in cases where judicial overreach was not just alleged, but proven. She had stood in courtrooms where every oddsmaker predicted defeat, and she had walked out with rulings that reshaped precedent. This was the background she carried with her into Congress. Yet ironically, her political identity overshadowed her legal one. To most of Washington, she was simply a rising lawmaker with a civil rights streak. Few remembered that before she was Congresswoman Crockett, she was Attorney Crockett, the woman who had made a career out of standing up to power and winning. And so, when Judge Howell's sharp eyes locked onto her that Friday morning, the judge thought she was addressing a politician speaking out of turn. What Howell didn't realize
was that the woman before her was perhaps the single worst person to underestimate, a congresswoman with constitutional oversight responsibilities, and an attorney with a masterful understanding of the exact limits of Howell's own contempt authority. To the crowd, Crockett's calm smile seemed like composure. In truth, it was something else entirely, the confidence of someone who had been here before.
The tension in Courtroom 22 was thick enough to feel in the air. Reporters leaned forward in their seats, pens poised. Law students whispered nervously, realizing they were about to witness something that would be discussed in classrooms for years. And at the center of it all, Judge Beryl Howell's voice rang out like a gavel itself. "Congresswoman Crockett, your comments to the press have undermined public confidence in this court's rulings. Such behavior may constitute contempt of court. You have 5 minutes to explain why I should not order your detention." The words dropped like a hammer. Marshals shifted, alert. The gallery felt utterly silent. This was the moment when most people, even seasoned attorneys, would fold, apologize, and beg forgiveness. But Jasmine Crockett was not most people. She rose calmly, leather portfolio in hand, and walked to the podium. Her movements carried none of the nervous energy the judge expected. Instead, Crockett radiated the same steady confidence she had shown countless times before, facing down authority figures who believed their power placed them beyond question. "Thank you, Your Honor," she began, her tone respectful but firm. "Before addressing your concern, I want to clarify the capacity in which I stand before you today. I am not counsel in this case. I am present as both a member of Congress tasked with constitutional oversight and as a licensed attorney with specific expertise in the limits of contempt power." The judge's eyebrow arched. This was not the plea for leniency she anticipated. Crockett reached into her portfolio and held up a neatly prepared memorandum. "With the court's permission, I've prepared a brief summarizing the constitutional standards relevant to this situation." After a moment's hesitation, Howell nodded. Crockett approached, her heels clicking against the marble floor. She handed the document to the clerk, then turned back to the bench. "Your Honor," she continued, "the Congress has been clear. In Bridges v. California, contempt sanctions are permissible only when a statement creates a clear and present danger to the administration of justice. My remarks yesterday expressed concern over constitutional consistency, hardly a threat to these proceedings." She produced another document. "Here is the transcript of my exact words, which you'll note began with the phrase, 'While I respect the court's authority.' This was a legal observation, not an attack on the court's integrity." Murmurs rippled through the gallery. Even the prosecutors glanced at each other, suddenly uncertain. Judge Howell leaned forward. "Congresswoman, questioning a court's application of constitutional standards in public can still disrupt proceedings by shaping perception." Crockett nodded respectfully. "Which brings me to Landmark Communications v. Virginia, where the court protected public commentary on judicial proceedings, especially from officials tasked with oversight. My statements fall squarely within those protections." She produced a third exhibit, her voice unwavering. "And in Standing Committee v. Yagman, the Ninth Circuit held that criticism of a judge is protected unless it is both false and malicious. My comments were neither. They were grounded in precedent." The silence was absolute now. Even Judge Howell, renowned for her iron grip on the courtroom, seemed momentarily still. Her stern expression had softened into something else, caution. Crockett pressed her advantage. "Finally, Your Honor, in United States v. Rodriguez, you yourself wrote that thoughtful criticism of judicial decisions serves an important function in our legal system and rarely rises to contempt. I stand here relying on your own words." That line landed like a thunderclap.
Reporters scribbled furiously. The gallery buzzed until silenced by a security officer's sharp glance. Judge Howell stared at Crockett, visibly recalibrating. What started as a show of force had transformed into a contest of constitutional knowledge, and to the astonishment of everyone present, the Congresswoman was winning. By the time Crockett closed her portfolio and looked the judge squarely in the eye, the entire room understood. The balance of power had shifted. What started as a contempt threat was becoming something much rarer, a federal judge being forced to reconsider her own authority.
When Judge Howell finally returned from recess, the energy inside Courtroom 22 had shifted completely. The intimidating certainty she had carried only minutes earlier was gone. In its place was something rare for a federal judge: hesitation, reflection, and even a hint of humility. Adjusting her glasses, Howell looked directly at Jasmine Crockett, who still stood at the podium, posture perfect, expression serene. The judge's words carried less thunder now and more weighty consideration. "Congresswoman," she began, "I have reviewed the materials you provided, as well as the transcript of your public remarks. I must acknowledge that your comments, while critical, were more nuanced than initially portrayed. Furthermore, your legal analysis is comprehensive, well-supported, and firmly grounded in precedent." A murmur rippled through the gallery. Howell, the judge who had just threatened jail, was conceding ground. And then came the moment no one expected. "In light of these considerations," Howell continued, "this court withdraws the contempt warning. Your comments fall within constitutional protections and do not meet the threshold for sanction." The silence was deafening. In a single sentence, the feared judge had stepped back, acknowledging not just the limits of her own power, but the strength of Crockett's legal argument. But Howell didn't stop there. Turning to the attorneys on both sides, she asked whether they would object to Crockett submitting an amicus brief on the very constitutional issues she had raised. The defense welcomed it. Even the prosecutors, after an awkward pause, agreed. And just like that, the woman who had walked into the courtroom as an observer and nearly left in handcuffs was now being invited to shape the outcome of a high-profile case. What began as a clash of authority and defiance had evolved into something unprecedented, a dialogue between equals. In the weeks that followed, Crockett's amicus brief circulated far beyond the D.C. courthouse. Law schools requested it for their classrooms. Judicial conferences cited the exchange as a model of how criticism, presented with respect and expertise, strengthens rather than weakens the system. Even Judge Howell herself began speaking publicly about judicial humility, using the confrontation as a teaching moment. And yet, when asked about the ordeal, Crockett never made it about herself. "This was never about me," she told reporters. "It was about ensuring that constitutional principles remain stronger than personal pride. The real victory here belongs to the Constitution." It was a statement that underscored the lesson every observer had already learned. When knowledge stands firm, even unchecked power must yield. And that is why this story will be remembered, not as a scandal, not as a courtroom spectacle, but as a powerful reminder that the law is strongest when it is defended with courage, composure, and absolute respect. If you found this story as extraordinary as we did, don't let it stop here. Like this video, share it with others, leave your thoughts in the comments, and subscribe to our channel. Because we'll continue bringing you real stories that prove knowledge, preparation, and principle can transform even the most impossible confrontations into victories for truth and justice.